answers to any question you have regarding immigration.
Can you file for stepchildren if you're divorced?
Yes.
That are in another country?
Yes, you can. Even if you're divorced, as long as you married the spouse before his children turned 18, you can file for the stepchildren. But what you would need to do is prove that you have an independent relationship with these stepchildren outside of this marriage to this man that you got divorced from, that you met these children, you correspond with them, you visit them maybe, you send money, that you have some independent relationship with them.
If you already filed for your green card and you're going through a process and your spouse's 2-year card is expired and it's almost been a year, what do you do?
As long as you filed the I-751 within 90 days of the expiration of his 2-year green card, his green card is extended by operation of law indefinitely until immigration makes a decision. So he is always going to be a lawful resident until immigration makes a decision. If they make a positive decision, then he's a resident for life. If deny him, that's when his lawful residence expires. Now, when you file to remove the conditions, in the past they would give you a 12-month extension on your green card. Now they're giving 18-month extensions. If that extension expires and you still don't have a decision, you're still a lawful resident of the United States. You just don't have evidence of it. You just need to go down to immigration and get a temporary stamp in your passport.
So my brother, I'm asking a question for him. He just graduated in the Army, graduated from bootcamp. He wants to know if he can file for our mom.
Only if he's a citizen.
So he has to get his citizenship first. Okay. And to file citizenship, what documents does he need?
He either has to show one of three. He's been a green card holder for 5 years. He's been a green card holder for 3 years. He's in a bona fide marriage with his spouse. Or he's been a green card holder for 1 year, and he's in the military. So I would go to whoever he goes to in the military. They'll do his citizenship for him.
But he has to
be in the military
get
for 1
that
year.
citizenship first before he files for his mother.
Even if he's in the military, correct.
I submit my VALA application on September. 2 weeks ago, the immigration sent me a ref. They need a clearance certificate from the police for my packing ground.
Right. You need to show for your VAWA that you have good moral character from every jurisdiction you've lived in since 16.
The thing is, 2 weeks ago, I got convicted with a misdemeanor for contributing dependency and delinquency for a minor. I left my stepson sleeping inside the house, and I left. The sentence is misdemeanor. The judge, he sentenced me 3 days in jail, suspended for 100 hours community service and probation. So I have certificate clearance from Phoenix Police, and I have the court paperwork. Is that a problem?
It is a problem. It sounds like it's a petty offense, but you still have to prove that you're a person of good moral character. Now that you have this offense, I would strongly urge you to get a good lawyer. And I think your argument would have to be, and I'm going to assume that you've never been arrested in any other jurisdiction. I am a person of good moral character. I had one bad day. I lapsed for one bad day. I had bad judgment that day. I take responsibility for that bad judgment, but I am a person of good moral character. I think that has to be your position.
Is it petty offense considered as a petty offense? As a misdemeanor?
It sounds like it's a petty offense to me. I don't know the Arizona law off the top of my head, but it sounds petty to me. But at the same time, you could be convicted of a petty offense, be admissible to the United States. It doesn't bar you from getting a green card, and they can still bar you for saying you have bad moral character.
Well, the penal code is the maximum penalty is 6 months.
Okay, it doesn't bar you from getting a green card. So you could be, for this offense, you can be barred from getting your green card, found inadmissible under 2 different theories of law. One theory is that you have a crime of moral turpitude that makes you inadmissible. You don't, because it sounds like it's a petty offense. Or it may not even be a crime of moral turpitude. I don't even know. Either way, the actual crime doesn't bar you. To get your VAWA approved, in addition to being admissible to the United States, which you are, you have to show you're a person of good moral character. And what immigration can say is, Despite the fact that this conviction doesn't bar you from getting a green card, we find you to be a person of bad moral character, because a person of good moral character would never leave a child alone in a home sleeping by himself. Your conviction sounds like it doesn't bar you from getting a green card. What may bar you is this conviction may indicate to the government that you do not have good moral character. That's different than I'm inadmissible. Those are two different concepts.
Back in 2008, I filed for I-360. I was adopted, but my adoption was approved the same day I turned 18. So I was 17, but turned 18 the same day the judge approved my adoption. After my high school, then I filed for I-360, Special Immigrant, because I had a problem when I came to U.S., so in North Carolina.
So in order to file for a Special Juvenile Immigrant, it has nothing to do with adoption. It has to do with somebody getting legal custody of you. And after they get legal custody of you, a judge makes a special ruling that you should not go back to your biological parents because they abandoned you, which it sounds like they did. I don't know whether you got that special ruling as part of this procedure. If you did, then you should have filed an adjustment application before you were 21. Now being 22, it's too late. You filed a Special Juvenile Immigrant petition. Was it approved?
No, it has not been approved. It only was accepted. They sent me a letter
all right, so stop there. What you need to do is have a consultation with me. Show me this adoption and guardianship. You're over the age already, so I hope you didn't screw yourself.
I came to the U.S. on a J1 visa, and presently I'm married with 2 kids, and I'm expecting the third one. So I want to know if there's a chance for me to adjust my status, and if you can.
Are you married to a U.S. citizen?
Yes.
And do you have a 2-year home residence requirement on your J visa?
Correct.
All right, so we have to do it. Yeah, I can help you. We have to get a waiver of the 2-year home residence requirement. It's either going to be done through no objection by your country and acceptance by the U.S. of the no objection, or based on hardship to your family if you had to go home for 2 years.
So my question is, I am not pleased with the way the lawyer here handled it. I'm in Dallas, and I want you to take up the matter for me. That's why I'm calling, sir.
All right, hold on 1 second.
I'm calling concerning a friend of mine who came here on a F1 visa. He came on a student visa.
Is he still on a student visa?
And then he dropped from school.
Oh, he dropped from school.
Yeah, he came on.
All right, so he's basically the father filed for him. He's over 21. He violated his student visa. Eventually, he'll get a visa appointment, but it'll be in his home country. He would have to do a provisional waiver, prove hardship to the father, go home and come back. That's the way it would work.
Yeah. So, like, his father is like his age, like 81 years of age. He's not like doing anything by himself. Like, is there a way of paperwork to be filed?
No, there's no helping father visa. There's no way to expedite it because the father's 81. God forbid the father were to pass away. While this case is pending and the guy who he's filing for is here in the United States and the I-130 is already approved, he can have a family member substitute in for the deceased father, and then he would be eligible actually to adjust his status here. We don't want anyone to die, but actually if the father dies and he has a close family member here, he's actually in a better position. As sick as that sounds.
Sir, I was approved my U visa in 2015.
Great.
So 2018, I filed my green card. I received my EAD card. So my question is, what is the next step, U.S.?
I think you should get a green card, because once you got your U visa, they shouldn't be asking you whether you refused to help. You already showed that you did help.
My daughter is in New York, and my fiancé migrated to the U.S. On March 2018. I came up in June for my daughter's graduation, and we decided to get married after the graduation.
Great.
He filed the documents in April, but I came home in June, and we still haven't heard anything except we got the receipt notice.
Okay. Well, you're gonna wait at least a year or longer. Why didn't you just stay in adjusted status?
Oh, it's a LPR. I could have stayed.
Oh, no. As an LPR? Actually, yes, because the priority dates were current.
Yes, it is.
Yeah, but I don't know about anymore. Thanks for watching. For more Brad Show Live, like and subscribe to our YouTube channel.